Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver, Colorado area. And I want to make a video about the kind of giving you a high-level oversight of what the probate process entails in Colorado, what steps need to be accomplished, and why it gets done sometimes. And really the important thing to understand about probate is it's the process to try and get everything resolved after a person has passed away, right? So we want to make sure that we've identified bills, we've paid those bills, we've identified any other creditors that might be owed money, we've paid those, we've filed a final tax return, we've identified the correct beneficiaries, those beneficiaries have gotten the right amount of money, and then once we're done with that process, we want to just close it up and be able to walk away and just know with 100% confidence that everything is done. No one's going to come back later on and say they're still owed money. The IRS isn't going to claim there's still taxes due. There isn't going to be another bill that shows up later on that has to be paid. Like, it's supposed to kind of be like, this is it. And if any of that stuff does happen and the probate was done correctly, it should be, a situation where you could say, look, you had your opportunity to find out about this. We did everything correctly, and you're out of luck. To get all that done, there is a process. In Colorado, that process, in a lot of cases, court has a pretty light touch, frankly. They're not really holding hearings, and you're not filing motions and getting orders and all that kind of stuff. The Colorado court gives you room as the personal representative to do what you need to do to get these things done. And there are certain steps that you do have to take, and the court does want to see certain documents filed to make sure that anybody who is part of this process has a fair opportunity to know what's going on and to assert their rights if they think they're not being represented correctly. So, thought I would quickly take you through like I say, high-level overview here. Within each of these steps, of course, is devil's in the details, right? Where we are trying to figure out, there's a lot of decisions that need to be made even within these. So it's not mechanical, but like I say, there's an order to these things. So when someone passes away, the first thing you really need to do is figure out, did they have a properly executed will? And so if they did, if you find that will, you are obligated to lodge that will with their county court. And that does not start a probate process. That does not get anything going as far as a court process for creditors or anything like that. That is just to make sure that the will is in the correct spot, that people can find it, if anybody has an interest, that it's there, and that if questions arise later on down the road, I mean, this happens, right, where people, even through our best efforts, we do the probate process or not, and years later on, something comes up, a mineral interest gets found, or some life insurance policy gets found that wasn't found at the time, or something happens where, something needs to be done, and it really can be an issue of, what did the will say and where is it and all that kind of stuff. So lodging the will is an important first step. And then number two is, once we have determined a probate is necessary or desirable for some reason, and that's not for everybody. Not everybody who passes away needs to have their estate probated. In fact, I'd say probably most people don't, frankly. We have another video up about how to determine whether a probate actually is required. The short answer is that if that person owns certain assets by themselves in their name, and they are worth a certain amount, which adjusts every year, for inflation, or included real estate, then a probate has to happen. There are other situations where a probate doesn't necessarily have to happen, but you still might want to do it to get like certain creditor claims definitely resolved or things like that. But that's a subject for a different video. But if you have determined that a probate process needs to happen for some reason, the first thing you do is you do file an application in the county court where the deceased person resided. That's usually the first choice. Sometimes that's not as straightforward as you would think it would be. There are a lot of situations where a person, had their home in a county and they got moved into some sort of long-term care facility at the end of their life that was in a different county, and so technically they died in that different county, but they still have the house in the previous county. There are situations where people own property here, but passed away out of state. So if that's not real clear, I would probably say really where the property is kind of a I would lean that direction. But if there's questions about that, you might want to consult a lawyer just to make sure that you're in the right spot. And then after you file your application, again, in Colorado, so there's a couple of processes available to you. I've described those in another video. There is informal and there's formal. I'm going to kind of assume an informal process here. In the informal process, what happens is once you file that application, the court clerk issues the person who's been nominated to serve as the personal representative a document referred to as their letters. And the full name of that document is dependent on whether there's a will or not. But the letters is the document that has the court seal on it. It's got the court, it's certified. It's got the clerk's signature. It is the document that you carry around to the various financial institutions or anyone else who needs to know that you need some sort of proof that the person has passed away and that you, the holder of those letters, has been appointed by a court to handle their affairs for them. And so that is kind of the critical document that gets everything going. And if you try and go into like a bank or a clerk and recorder's office, and you say, "Oh, well, I'm the kid, and my dad passed away, and here's the will saying I'm his personal representative, and all that kind of stuff. I'm here to collect his assets." Well, they're going to say, "Well, we don't know if he's dead, right? We don't know if you're his son. We don't know if this is the most recently executed will. We don't know if this will was executed validly." This letters document is the document that, is the court saying we have confirmed these things. Okay. And so, the application in Colorado, pretty straightforward. It's kind of a fill in the blank thing. It's like, 2 or 3 pages long. You're filling in the name, the address, the person's, where they passed away, when they passed away, where they were resident, whether they had a will or not, those kinds of things. And so it's not that hard. The one part, again, tricky part can be listing their heirs at law. Okay, so you got to do that on the application, and you got to get that right? So you got to know what that means. Like, did the person have stepkids, biological kids? Is there, a spouse? Like, how were these people related? All those things can kind of really, they really do affect, who is entitled to receive notification of all this, and who's entitled to receive what, and if there's a will, who's in that will, and all those kinds of things. So just getting that part correct is very important. Once you have your letters, so like I say, as part of this process, you are going to really, notification of heirs is a big part. Heirs, beneficiaries, anybody who's entitled to kind of know about this. And I err on the side of notifying too many people as opposed to too few. Sometimes people are kind of like, I don't really want to notify their son or something like that. He's kind of don't even know where he is. He's pretty combative. He's going to be a problem. Well, you'd rather find that out now, right? And you don't really have a choice, frankly. I mean, the law says if it's a son, even if they haven't talked in years, even if there is a will leaving him out. Again, you might think, well, they left a will, and this will says here's who gets this money. But on the application, you have to list the people who would have been entitled to receive money or assets if there wasn't a will in place. Because again, they might have a claim. They might have a claim that will was invalidly executed, they were unduly influenced, they were kind of pressured into doing it by the person who got everything, and the only way they can know that they have a right to make that claim is if they get notified that this is going on. So again, you kind of want to make sure you know who those people are and that you do get them notified. And if the news is bad, on whether they're going to kind of challenge this thing, it's like, well, that's not great. But again, you kind of want to find this out now and not 5 years from now when things have gotten cold or money's been distributed or things like that. So after we get the application, after we get the letters, we fill out what's called an information of appointment. Your information of appointment is the document that lets people know, like, hey, a probate process has been opened, and you might have rights in this process. Here's the case number. Here's the court. Here's how to contact. If you want to find out more information, please, here's what you do. So the court wants to see that go out because again, they want to see proof that the people got it, because again, they're kind of relying on those people to let them know if they think there's an issue, and if there is no, if no one lets them know, then they assume everything's fine. But that process is all dependent on making sure that the right people have been notified. Okay, and then as we're doing this process, one thing we got to do is create an inventory. The inventory is just a pretty simple list of the assets that the person had that are going through probate. That's a key thing to understand, right? The person might have had a very large IRA, for example, or a life insurance policy. Like these things might be the bulk of their estate. If those items had designated beneficiaries on them, they're being distributed through those instructions and not through the probate process. So you wouldn't list those on the inventory necessarily. And then there might be other items. Again, you might feel like, well, this is small, this doesn't need to go on there. Like, well, it does if it's part of the process. So this is supposed to be available to the heirs and also to creditors to kind of see, well, what is in this probate process? You know, when the heirs are kind of, if there is anyone out there that is trying to determine, like, should I challenge this will? Should I be part of this process? Do I need to have a lawyer? All those kinds of things. They kind of need to know what's at stake there. And so having that inventory can be obviously pretty critical to them. And so you do the best you can to list the assets values, right? So if you have a house, for example, you're kind of, you know, you might have to have it appraised. A lot of times we do our, you know, kind of a good faith estimate. Again, it depends on if there are people out there that are kind of combative about the whole thing. If everyone's working together and kind of agrees on what that value is, that's probably okay. You list bank accounts, financial accounts, personal property. If there are life insurance policies that did not have designated beneficiaries or were designated to go to my estate, those would be part of the probate process. So there is a form available on the court websites for the inventory, and it's kind of, again, the boxes are laid out. You fill those out. It also includes debts so that people can understand, okay, yes, they had a $600,000 house, but it had a $500,000 mortgage on it. So we really only have $100,000 of equity here that we're talking about. So the inventory, in an informal process, you know, it gets made available to anyone who asks for it. In a formal process, you actually have to file it. And then we get down to step 5, which, as I kind of alluded to earlier, notification of creditors. And this is the part that people kind of don't really think about when they're doing their estate planning, or even at the start of this process when we're dealing with personal representatives. They're focused on the heirs, they're focused on the beneficiaries, they're focused on the people who are going to get gifts through the estate. Creditors are out there too. There are always creditors, even if the person really didn't have debt at the time of their death. A lot of times you pick at least some up, you know, if there's any medical care or anything like that, you know, bills will be coming. If there really any bill that shows up after a person has passed away is a creditor claim against their estate. So it might be a $100 cell phone bill, right? Or a, you know, Comcast or your water bill or something like that. Like somebody's got to figure out, okay, how many bills came in? How much is owed? You know, who's owed what? Are these debts that really need to be paid? Is it credit card bills? Like obviously a mortgage and a credit card bill, kind of different levels of, you know, who's getting paid back, those kinds of things. So if there's not enough money in the estate to actually pay those off, then it gets interesting to determine, okay, what order do these bills get paid off in and who's getting what? So, but again, notifying the creditors. Again, a big part of this is making sure that, you know, you can rest easy when this is all done and know that all bills were found and paid. And if you didn't correctly notify the creditors, you're not really going to be able to kind of rest on that front. And in creditors, there's really 2 types of creditors. There's known creditors and there's unknown creditors. Maybe. You know, so anytime you get a bill, that is now a known creditor. So you got to take care of them in a certain way. And then for unknown creditors, depending on how long it's been since the person passed away, you might need to run a newspaper ad over, in that person's county, just announcing this probate process has been opened. This person has passed away. If you think they owed you money, let us know. And once that newspaper ad runs, you know, they've got 4 months to actually assert their claims if they think they were owed money. And then if you get a claim, it's up to you to determine, you know, is this a valid claim and all that kind of stuff. So known creditors, again, that can be a bill coming in. It could be a situation where it's like, look, this person was in the hospital for the last month of their life. I haven't received a hospital bill yet. I know one is coming. Like, you know, again, I can't hide behind the couch and hope that the creditor doesn't find me, right? I got to kind of proactively reach out to creditors that I know are out there. Because again, I want to get this stuff resolved and move on with my life after it's all over. Okay, so once we're here, we know who's involved, we know who the heirs are, we know who the beneficiaries are, we know who the creditors are, we know what we've got, what we're working with here. At this point, we do the administrative stuff. And by that, I just mean here's where we figure out, okay, we have a house. Are we giving it to one of the beneficiaries, or are we selling it? Usually you're selling it, right? And then distributing the cash. What are we doing with the personal property? Are we dividing this up? How do we decide if two people want the same thing? Who gets what? All those hard questions, really, that a personal representative has to deal with about how we are actually turning this estate into something that gets distributed and to the right people and all those kinds of things. So it's kind of a boring word down here, administration, but it's a lot of times where all the excitement happens, actually. So we do that, and that can take a varying length of time. It's hard to tell if we've got a house. If it's, sometimes we're dealing with properties that are not real easy to sell. Right now, as I'm making this video, the real estate market in Denver is incredibly hot. You can sell your house pretty much the day you put it on the market. That, of course, is not always true. Sometimes it takes months, or sometimes, more often than you might expect. The person who's living there had hoarding tendencies, and there might be a lot of work that needs to be done on the house, or things that need to be cleared out, and so it can just take a lot of time, and sometimes more time than people expect. So that is, this part varies a lot from probate to probate. And then once we get through that, as we're doing that, we're supposed to be keeping an accounting. And the accounting is really just a chronological list of all the transactions that we did since the person passed away. So the inventory was a snapshot of what that person had at the moment they passed away and the value of those items, right? So we kind of know what we had when they died. As we're doing things, as we are maybe fixing up the house, for example, maybe we pay a painter to come in and paint it. So we're paying money out. We pay someone to come in and clear out junk. We donate some items, we sell others at an estate sale. So as we're doing the administrative stuff, we've got money coming in, money going out. It's just like a little business here. So the accounting is really not the most sophisticated legal or financial document in the world. It sounds intimidating, but we're really not doing, real sophisticated dividing things up into various types of assets like real accountants do. This is really just a chronological list of here's all the money that came in, here's all the money that went out. You have the inventory, so the accounting is supposed to explain how did we get from this inventory to the check that you're holding in your hand. Or if you're a creditor and you're thinking, well, I didn't get the full amount, I want to see how this went down. They get to see the accounting too. And if anybody is suspicious about, the accounting, let's say, there's a $5,000 visit to Home Depot on there, and you're kind of like, well, it doesn't seem like there was $5,000 of work done to this house. We want to see that receipt. We want to make sure that you really spent the money on, items that were put into the decedent's property and not your own, right? So you have to produce those, right? So this could go on for months or even years, and if someone asks for a receipt years later, you kind of got to be able to produce it. So it's very important that you really do keep track of your expenditures and documentation as much, as best you can. It's really important. And again, you should not just assume it's going to be your family asking. There could be creditors, there could be other people out there that you're not expecting who might ask for those things. And so really important that the accounting be done correctly and that the information be done right. And then once the accounting is done, we just wrap up. Again, there's a difference here between the informal and the formal process in Colorado. In the informal process, you just file your statement of closing, just letting, kind of affirming under oath to the court that I did everything, I have notified the beneficiaries, I have notified the creditors, I have made the inventory available, I've made the accounting available, all the assets are distributed, all the creditors are correctly, have been correctly accounted for and paid or otherwise resolved, and I'm done. And again, the court kind of rubber stamps that, similar to what they do with the application in the informal process. They just kind of assume that everything was done correctly if they haven't heard any complaints up to that point. The drawback of using the informal process, because the court never really did closely evaluate what happened or heard any complaints or anything like that, is that the personal representative is still on the hook for another year after they file that document. So if someone shows up and says, hey, I was not correctly notified, I didn't get information that I needed, or that it wasn't done correctly, the personal representative's got to be concerned about that for a while longer. The formal process, there is more court involvement, probably more expensive. You might have to have a lawyer to do it, all those kinds of things, but the nice thing about the formal process is that your liability is cut off much sooner. So 30 days after the court hearing gets scheduled, your liability is ended. So that's why you might want to use the formal instead of the informal process. But I kind of suspect, I haven't seen statistics on this, but I suspect that the vast majority of probates are done informally. So that is my high-level overview of the probate process. Like I say, within each of these steps, even the application, right? If you pull the application and look at it, it's like I say, it's a fill-in-the-blank document. It's 3 pages long. It looks very simple. Listing the, trying to determine who should be listed on the beneficiary section. The heirs section can be difficult. All these steps have decisions that need to be made, and so you should make sure you understand the probate code and kind of have reviewed this whole process and understand what you're trying to accomplish so you can do it correctly. If we can be helpful in that process, we would love to have the conversation with you. If you're dealing with an estate in Colorado, again, we're the McKenzie Law Firm. Our phone number is 303-578-2745, and again, reach out. We're here and happy to help. So hope this video was helpful, and appreciate you watching. Thanks.